what he has said I'm going to do and what I'm going to do. We know how the process has run up to now. I think most of us have been involved in it, so I will not discuss that in the interest of time. You know the acts that we're talking about. We have the Relations Act, we have the Employment Institutions Act, Work Injury Benefits Act, and Occupational Safety and Health Act. This approach that you take is not for purposes of giving a critique. What we are going to try and do is to present to you some of the issues that have arisen or have been raised with respect to those laws based on the Constitution of Kenya 2010, and Justice mentioned some of them, and the experience that some of you have had, that is in respect of KOTU and also in respect of FKE. Then I will also do something else, and that is to say, as you debate these particular issues that I have raised, can you also consider certain things? And those certain things will be things arising out of the ILO conventions, out of the Constitution of Kenya, and out of experience. So I will not be giving you any advice. I will not be suggesting to you what you must do. I will only be suggesting to you what you must consider when you are engaged in that debate and you are making some presentations in respect of what changes that you actually want. A caution here, these are not my proposals. If you find any proposal involved in it, it is not my proposal. If anything looks like a proposal, it has come out of the consultations that we have held over the last 3 or 4 months between myself and Jacob, and KOTU on the one hand and FKE on the other. So I'll follow the acts just like they were listed. And the first one is the LRA. And the first thing that is being proposed is a diffusion of the powers of the minister. If you go through that act, you will find that the minister has many powers, some of which are actually discretionary. He can decide, or she can decide, what to do. And there's a proposal that we diffuse those powers. Some of them can be taken to the National Labor Board and also to other institutions that have been established. The second thing is on freedom of association, which is part 2 of the Act. And there is a proposal that there is payment of compensation for losses when you have unprotected strikes. This is something that is at the heart of employers and understand it. But as you debate that particular proposal, please think about the constitutional protections that have been given to the right to strike. And you had Justice saying that if there is no specific provision, then they go to the Constitution. So if you don't lobby for specific provisions that are in line with the Constitution, then you will still end up with a situation where compensation becomes an issue or a problem. Of course, you know that ILO Convention 87 and other international instruments actually recognize the right to strike. And the only thing that they talk about is that that strike should not be violent, it should be peaceful, it should not interfere with other people's rights. And then we have the Committee of Experts, which is a committee of the ILO, which interprets the conventions and recommendations of ILO. And they have given a very, very broad interpretation of the right to strike. Now, those interpretations are the ones that are applied by ILO. If they come here, for example, to investigate allegations, they will take those recommendations into account. So you can't ignore them. And they are a group of very, very strong experts in the area of labor law. Disputes relating to freedom of association, there is the issue of who should be listening to these things. And the proposal is that let us have a situation where we operationalize and involve the Conciliation and Mediation Commission in the area of dispute resolution. And if that happens, then we should have a service secretariat we should have enforcement powers, we should have referrals and appeals from the decisions of the CMC, and we should devolve the CMC. Now, this is something that I think is very, very important for us, because we know that the minister is overwhelmed. We also know that the courts are overwhelmed. If we can have the CMC, that will assist in ensuring that a lot of the disputes are sorted out before they go higher up. The third particular area is sector-based trade unions and employers' organizations. Unfortunately, as things stand today, the registrar's authority allows him or her to establish cross-sectoral trade unions and cross-sectoral organizations. He or she had power on Article 41 of the Constitution on the freedom of association, and Article 2 of ILO Convention 87 on freedom of association. You need to look at the IRC and see if you can use IRC as a framework for proposing that we should have sector-based trade unions and sector-based employers organizations, because that is what was envisaged in this particular IRC. So that may be used as a basis for arguing for sector-based trade unions. Just remember that as you are arguing for that, if it is ever put in the law, it will take 2 to 3 years for the trade unions and employers organizations, less employers organizations, but for the trade unions, it will take 2 to 3 years to reorganize them into sector-based unions, quite apart from the fact that they may resist that particular proposal. Then sections 12 and 14, there are arguments that the two certificates should be made into one, so that we go back to the pre-2007 position, when we only used to have one certificate. Now, Section 12 offers a certificate for purposes of promoting a trade union, and then Section 14 is once you are registered, you are given a certificate. The proposal is to go back to what we used to have before 2007. Then, in respect of addresses, the suggestion has been that we have other forms of addresses. There have been very many changes. You have Twitter handles, you have Facebook, you have emails. So why should we insist that all these addresses should only be a certain type? Timelines, notices, and registration, there are discretions under sections 18 to 20 where there are no provisions for specific timelines, and the proposal is that we impose timelines on the registrar. Statutory qualifications for officials of trade unions and employers organizations, the proposal is that we put those in the Constitution, in the LRA, so that you have it easy in terms of negotiations. And of course, I do appreciate the fact that at the practical level, some of the people that you have to negotiate with may not understand some of the provisions of the law. And that, of course, is a legitimate issue. But as you do that, please remember that there are sections of the Constitution that prohibit discrimination. And then you have Article 41 of the Constitution on freedom of association. Then you have, of course, the usual Article 2 of Convention 87 on freedom of association. Then you have the fundamental provisions of Section 4 of the LRA. Those provisions actually talk about freedom to associate and freedom to run the organization and freedom to be elected or to elect. So if you're going to impose any of those qualifications and with provisions, then of course there's the issue of whether or not it is practical to insist that people who become officials of employers organizations or workers organizations must have certain qualifications. It is going to be very difficult, first of all, to determine what qualifications and actually to agree on it across the board before you can put it into law. But remember that there are certain exclusions that are acceptable to the law, and that is, for example, if somebody has committed fraud, if somebody has committed any offense to do with fraud, do with destruction, stealing of property, those kinds of exceptions are acceptable. So those ones you can push because even the law accepts them. Then we have the application of funds to pay for property destroyed or lost or compensation during a strike. I've mentioned that earlier, that if you go that direction, you will have a few things to contend with, both the Constitution and ILO conventions, and also the interpretations that have been given by the committee of experts. Trade union fees and employers' organization fees are suggestions that penalties should be given if the deduction is not done, or if the deductions are remitted late, or if they are not remitted at all. And my suggestion is, can you identify the circumstances under which you should actually have a penalty? Because if you have an employer like the University of Nairobi or the universities in general, public universities, which get part of their capitation from the government, and the government has not given that amount of money. Now, the basic pay of university lecturers and actually other staff as well comes from the capitation. So if the government has not given that money and the university cannot pay the salaries, what then happens? Of course, there's an argument that the universities get extra money from Module 2, which is true, but Module 2 has very, very specific payments. For example, if it is paying a lecturer, it is an extra payment for teaching Module 2. That is beyond the normal teaching that you normally have. So if you have an employer like that who can explain why they were late with the payment of those fees, what are you supposed to do? So we can't just have a blanket provision that says that if you are late with the payments, then you need to be penalized. Deduction of agency fees, and I know there are trade union representatives here, have a very, very strong position on this, and we have argued over and over with the trade unions about it. First and foremost, you must ask yourself, when you impose this fee, who is going to deduct it? It is the employer. That adds an extra layer of the activities of an employer. So you need to consider what role the employer is going to do in deduction of these fees. And secondly, you have to consider the non-discrimination provisions of Article 27 of the Constitution. Now, I keep arguing this, and I know there is a lady here who is vehement against it, but I keep on arguing it, that the application of any provisions of a CBA to a non-member is not based on an agency relationship between that non-member and the trade union. It is based on the fact that an employer cannot discriminate between two employees who are placed in the same position. If I am a clerk and Otieno is a clerk and Otieno is being paid 10,000 shillings, we are both doing the same thing. You cannot then tell me that because I am not a member of a trade union, I don't contribute to the trade union, I must then pay. That is unconstitutional. It doesn't matter how many times you talk about Article 24, it is still unconstitutional. There is no provision that allows you to take the property of a particular person without their own agreement. So much as you may argue otherwise, that will be a different interpretation of the Constitution. And finally, there is the right to property, Article 40 of the Constitution, that says you must not deprive a person of their property without their consent. I do not know where the exception comes from. And finally, you cannot apply contractual obligations to a person who is not a party to a contract. The relationship between an employer and the trade union in terms of a negotiating, the relationship between a member of a trade union and a non-member, those are two different things. You cannot, the non-member is not a party to any of those contracts. So you can't apply the provisions of that contract to the particular person. Then there is the recognition of trade unions and collective bargaining. There has been a proposal that we have automatic recognition. Please remember that under Section 54 of the LRA, The idea of recognition is for purposes of collective bargaining. That is a phrase that nobody ever talks about. That means that for all other purposes, a union is recognized as soon as it is registered. For all other purposes, a union must be recognized as soon as it is registered. Once it gets a certificate of registration, it should be recognized. So there is general recognition under the LRA. Apart from that, there is the right to engage in collective bargaining under Article 41(5) of the Constitution, and there is no exception there. And then on ILO Convention 87 also talks about freedom of collective bargaining, and again, there is no exception. So there could be difficulties in recognition of several trade unions, and you may find a situation where, as a matter of fact, there are many trade unions that exist in a particular area for purposes of negotiation, and you might have difficulties. But I think in this particular case, what we need to do is not to abrogate the Constitution, but think about different ways in which we can collectivize the efforts of those many trade unions who are wanting to enter into CBAs with a single employer. For example, if you have a law that says that all the trade unions who have memberships with a particular employer must form a negotiating committee which then goes to negotiate with the employer, that will sort out the problem. But we think in terms of recognition by way of exclusion and as a problem. Then we have the issue that collective agreement continues to bind all employees and employers even if they have resigned. Where on earth have we ever had that a person is actually bound by an agreement that they have exited? It's not anywhere. And Article 2 of the Constitution, Articles 2 and 3 of Convention 87, Article 36 of the Constitution on general freedom of association, Article 41 of the Constitution and the freedom to join or not join a trade union, all those articles talk against forcing somebody to engage in an agreement that they have gotten out of. Please remember that here they are not referring to obligations that arose before the person exited. They are referring to the person having exited, and now there are new obligations arising, and those obligations are being imposed to that person who has exited. It doesn't make sense, but it is there. You cannot extend contractual obligations to non-parties. But I make a distinction between things that arose when you were a member, which you are obligated under, and things that arise when you have ceased to be a member. The role of conciliation and mediation commission, I think that is something that we need to argue for, and we need to actually insist that this CMC be established and that it be devolved so that it can sort out many of the problems that go upwards. Service of a report of a dispute to include other modes of communication that we have talked about. Let us expand the modes of communication to take into account the new ways of communicating. Essential services, that again, I think is something that is very much in the heart of employers, and I think the CEO talked about it when she was giving her remarks. Remember that as we are debating that particular issue, there is a protection of the right in international instruments, the right to strike, of course, with certain exceptions. And then we have talked about the constitutional protection, and then ILO Committee of Experts Interpretation, which is very wide in terms of how you define the right to strike. It is very narrow when it comes to determining what a protected or essential service ought to be. So as we debate that, it is important for us to think about those specific areas. Sorry, I'm rushing you, but that is my brief. The Employment Act, in respect of general principles, the first thing is employment policy on sexual harassment, where employer employs 20 or more persons. As we discuss it, what is the magic of 20? Why not 5? Why not 1? Why not 50? Why not 100? Is there an explanation for that number? Are there other ways of protecting employees in terms of sexual harassment? So for example, if you are an employer of one person and they are of the opposite sex, like let's say a house help. You have a house help who is a lady and you're a man. Are there ways of protecting that person from sexual harassment without you having to write an elaborate policy regarding? So you can talk about one person, but say, why don't you just tell this person what the law says about sexual harassment? And that would be enough. Okay? Then employment relationships, we have talked about this many, many times. Non-standard forms of employment, whether and if so, how they should be regulated. Now, there are some of these things that are difficult to regulate, very, very difficult to regulate. So we need to think about how to regulate them. And as we think about that, can we think about the ILO conventions and recommendations, the Constitution, and the practicality and effectiveness of any method that we select for purposes of dealing with the non-standard forms of employment. They raise very many questions, very, very many questions. And I think we have talked and talked about them, so we need to think very, very seriously about how to deal with them. Some of them we might find that we don't have to regulate. And if we don't have to, there's no need to worry about it. But the ones that we can regulate, let us find the different forms in which we can regulate them. It doesn't always have to be a law. You can have codes of conduct entered into by employers or employees so that certain things are regulated in a particular way. Payment of wages, there have been suggestions that we use other forms of payment like mobile money transfers. Here, of course, what you have to think about is how convenient is it for both parties and how safe is it. Penalizing delays in payment, I think you need to think about the reasons that lie behind delays. Don't just have a blanket provision that says anytime you have a delay, you get penalized. Itemized pay statements. The idea here is to unpack this thing called gross amount. There are, as we are thinking about this, you need to consider the employer's position. You need to consider the employee's interests. And you also need to consider that there's a government which sometimes wants to know what does that amount stand for. For example, the Ministry of Labor and Social Protection may want to know, when you have this amount of 20,000 shillings, what does it stand for? KRA would like to know, because some of those things can be taxed, others don't have to be taxed. So as you think about either saying we should have or we should not have, think about those demands that we have in practical terms. Annual leave, the number of days that are given sometimes differ. The bottom line usually is 21 days, but for the public service is 30 days. There is a suggestion that they should be harmonized, whether it is 21 days or 30 days, they should be harmonized. And the thing to think about is that the Constitution talks about non-discrimination. So there's no reason why you should not have a bottom line that is applied to everybody. Then if you want to raise yours, you can go ahead and do so. Taking of leave mandatory, that can be done by law, but the fact is you must think about the rights, the interest of the parties. I've given the example where you find that an employee is unwell, and because they're unwell, they are still working, but they accumulate large bills, medical bills, and they tell the employer, look, I'm accumulating a lot of bills. If I go on leave, then it means I will not be able to pay these bills. Can we agree with you that I actually work for this 1 month that I'm supposed to go on leave, and then pay me for the leave days? Because I want to use those leave days to pay my medical bill. That's just an example. There may be many situations where flexibility is required. So as you think about making leave mandatory, you need to think about those kinds of situations. Maternity and paternity leave, there have been suggestions that we have bonding leave where a couple or a person has adopted a child, that the days of leave should be constituted by working days and not just the total week. And then that if a contract ends during maternity leave, then it should be extended to take into account the maternity leave. Those are things that I leave for you to think about. Just remember that when you're talking about maternity leave, the most important thing in life is producing new ones. And you went through it yourselves, you are produced. So when you're thinking about maternity leave, always think about the fact that my mother produced me, and I would have liked her to have enough time to look after me when I'm still in the womb and look after me when I'm outside the womb. Grounds for summary dismissal for unprotected strikes. Again, you have all those provisions that are contrary to it, and you need to think about them as you make those proposals. And remember also that strikes are always very controversial and complex. So there is no straightforward way of dealing with strikes. They are both a legal issue as well as a political issue. I remember one time when the universities were going on strike, we were called for a Senate meeting at 3 o'clock on a Sunday. And we were told that the university did not want the strike. So the chair asked me, okay, Showiti, as the Dean of the School of Law, what is the legal position? I told him the legal position is simply that the strike is illegal. Then he produced a statement that said that if the strike is illegal, anybody who goes on strike shall be sacked. And I raised up my hand and he said, okay, what is it? I said, look, I said that the strike is illegal, but a strike is both a legal issue as well as a political issue. That statement does not deal with the political part. So we negotiated, and eventually I was asked to revise that particular statement that said that the university is going to offer 100 million shillings and we will negotiate the rest of the amounts, but under these circumstances, if you go on strike, you will face the consequences. So there was both a carrot and a stick. Payment for wrongful or unfair dismissal, somebody is suggesting we remove the maximum amounts, and the argument was that it gives courts and any person making decisions some kind of discretion to look at the specific circumstances. Constructive dismissal is something that has always been applied by courts, but some people are suggesting that it be put in the law. That is something that you can debate and decide on. Protection of children. Remember that there is reporting under Section 54 of the Employment Act, and it's being proposed that we include the administration and children's officers as people to whom you can report if there is child employment. Then there is also a suggestion that we enhance penalties under Section 64 and 65 as a deterrent. Anytime that you're thinking about enhancing any punishment as a deterrent, ask yourself, what does the science say? The science doesn't say that the higher the penalty, the higher the deterrent. The science says deterrence is not brought by higher penalties. Very often it is alternative ways of dealing with a problem, like explaining to people, talking to people, educating them, that actually gives you deterrence as opposed to straight enhancing of penalties. Insolvency of employers, at the moment the payments are taken by the minister from the NSSF, and there's an argument that instead of taking workers' money to pay other workers, why don't we establish a wage protection fund? And that's something that you can debate. Dispute settlement procedure under the EA, we can integrate that in the LRA because there are already dispute settlement frameworks in there instead of having them in the Employment Act. Labor Institutions Act. By the way, as we go along, you will find that the suggestions get less and less, so we will take less time in the remaining ones. There's an exclusion of NYS in the Act, the Labor Institutions Act, and the argument is that why? There's no basis because NYS is not a security body. It is not a military force. It's not a paramilitary force, not the police. So why there's no explanation for that? So it should be included in the Act. The National Labor Board has been talked about and talked about and talked about for a long, long time. And the proposal is that let us make it autonomous, give it a budgetary allocation, and we also relook at the membership of the National Labor Board to ensure that it can be effective. And it may be the one that takes over many of the things that are being done by the minister. And it may also be effective in dealing with the many problems that we talk about: recognition, what level of unionization, the issue of sector-based things. All those things can be dealt with by the National Labor Board. Committee of Inquiry, the proposal is that the membership should be reduced from 10 to 7, and that people who are appointed should be people with expertise to be able to solve the problems that exist, that it should submit its reports periodically, and the talking is that it should submit the reports immediately 30 days after being appointed. Labor administration and inspection, period of retention of collected documents, it's being argued it should be reduced to 21 so that you don't have the administration keeping your documents for a long time. Penalty for breaches of confidentiality, the idea was that we increase the penalty, but as always I say increment of penalty does not necessarily give rise to deterrence. Membership and appointment of wages council, number of members should be reduced. Mandate and whether work should be tied to Labor Day. The argument is that let this thing continue to be working continuously, so that in effect they can carry out research, they can determine what are the correct wages, what are the best terms and conditions, instead of waiting until just about Labor Day, then they tell something to the minister in terms of the minimum wage, which is the only thing that is usually announced. Period of retention of records, we have dealt with that particular one. Employment agencies, should they be required to make periodic returns? And the proposal is that yes, they should be required to make periodic reports to the authorities, to the administration, just like everybody else. Work Injury Benefits Act, the suggestion is that we should change the name from Work Injury Benefits to Work Injury Compensation. So it should be Work Injury Compensation Act. That's the proposal. And what is contained in that act should not be called benefits, but should be called compensation. That is the proposal. In part 1, there's a suggestion that when we define a dependent, we should not use age. And the reasons that have been given are that sometimes people who are 18 and above are still actually being looked after by the employee because they are still in school, because they have a disability, because they are aged, whether it's premature aging or normal aging. You might find somebody who is 84 years, he is my father, and I'm still looking after him, and he's dependent on me, so the issue of age should not actually arise. That is the argument. Obligation of employers, the minister usually has power to decide whether to accept specific insurers or to give an exemption to an employer to use security. Meaning that if the employer can prove that there is somebody or some institution that can give security, then it is not necessary for them to take insurance. The argument here is that that exemption should not be there at all. All employers should be asked to take insurance with respect to obligations. Whether we should have registration of employers both under WIBA as well as OSHA. You know that the Occupational Safety and Health Act already has an elaborate process of registering employees. And incidentally, in respect of OSHA, the place is called, the employer is called an occupier. So if you register an occupier under OSHA, and that occupier is also an employer, why should they then again be registered under WIBA? That's the argument. Right to compensation, there are suggestions or proposals that we should also compensate people who get injured or compensate their families if they die in the course of work or duty due to terror or security-related attacks and due to natural resources, natural disasters. Now that is something that you can think about, because if somebody is working and in the process of that working, something happens like happens in Dusit Hotel, should the person not be compensated? Those are issues you can think about. Reporting of accidents, there is a proposal that trade unions should also receive a copy of that report. There were arguments against it, excuse me, in the sense that the works committees at the shop floor also have members of trade unions, the shop steward, and therefore they get that information at that point when it is being shared. But others are arguing that we should get the report that is being sent to the director of OSH to also the trade unions. Again, compensation, there's an issue as to whether there should be a limit, because there is a limit in the Act, and the argument is, why don't we remove that limit so that whoever is making a decision on the amount of compensation can have the discretion to actually make a decision, taking into account the circumstances. The general comments and proposals regarding OSHA were that all the penalties in OSHA should be enhanced. And again, I make the point that penalties do not always give rise to deterrence. Then involvement of trade unions in matters of workers' rights, that when you are dealing with OSHA and an employee is injured and they belong to a particular trade union, then the trade union should be involved. That was a proposal, and that you can discuss. General duties, inclusion of electronic systems of communication, that has been talked about virtually everywhere where there are notices and other communications. Administration, the Act under Section 26 says that safety and health officers should have certain degrees. And the proposal is that we should have at the end what the lawyers call an omnibus provision that says any other relevant degree, so that any other groups of people who have degrees and are able to work within that particular area can also be appointed. The member of the National Council of OSH, there is a suggestion that we also include the ministry in charge of labor and a representative of human resources